Can we talk?
Can we talk?
Can we talk?
¿Podemos hablar?
Can we talk?
All right, well, welcome back, everybody, to the Can We Talk podcast by the Colorado River Regional Crisis Services. My name is Lily. I'm the Community Outreach Educator, and we have a few guests with us today.
Hello, my name is Ashley Stewart. I work here as a case manager and the legal lay advocate.
I'm Sergeant Gomez from the Parker Police Department.
Awesome. Well, today we're going to be talking about orders of protection, injunction against harassment, and some of the things that go along with all of that. So we mentioned children a couple of times, and I know that having children, especially if the petitioner and the defendant have children together, I know that can kind of make the situation muddy.
Very.
So what if someone is concerned about the safety of their children, but they have a protection order against the father, the mother, the relative? How does that work?
That is a lot, and you have to really think about what you're doing, especially when you do the order of protection. I really would like everybody to think about that, because when you get an order of protection, you have to be very thorough, like we've talked about incidents, what's going on and stuff like that. When you try to add your children onto that, you have to specifically provide events where that other party was a danger to the children. You have to put it in there. You have to show, what's going on and why is it a threat to the children.
What if there is a custody order in that? So let's say they're separated and there's a 50-50 custody. One party has an order of protection or is wanting to get an order of protection. How would that work if they have to do a handoff with the child or with the children?
They will recommend that you go back to the court where you had your child custody battle at. That's where your venue, or where you had your court, that's basically your venue. That's where you have to go back to, because the judge is familiar with what's going on. So if you do a file for emergency custody or child custody or anything, not child custody, but order protection, emergency order protection, you have to go back to that judge. And then there they'll listen to you, and then they'll grant it or not. Most of the time, that's been what's recommended to me, that you go back to that judge, because the justice court will try not to get involved with a civil matter and try not to override another judge's order. And they'll go take you back to that judge to go ahead and do that. It's not very convenient half the time, but that's, in my experience, that's what's been happening. But if you don't have any court orders or don't have any child custodies or anything like that going on, you can go to justice and you can still get that emergency custody.
Just to recap with the children, they can put their protection order, they can put their child or children on their protection order so that they don't have to get a separate one for their children if there is a danger, but they can include them on their protection order? Or do they have to get a separate one for the children?
So for an order of protection, they can just put it on the emergency one. The judge then will go ahead and decide for themselves if they're the judge for the child's custody, exactly how that's going to turn out. Just because a lot of judges don't like to override another judge about what their previous custody battle was going on, and they know a lot more information than the other judge.
So kind of going off of children, we have clients that come in here and say that their pets are their children. What if someone's concerned about the safety of their pet?
The pets can be added on there too. Yeah.
Really?
Yes, they can be added onto the order of protection. You just have to be very thorough about it. Who owns the pet and why you want the pet on that order of protection? Because sometimes the judges will be okay with that and just, okay, you'll add your dog, that's fine.
Oh, interesting. Let's say the defendant has guns and the petitioner is afraid that they might be used to hurt them once the paper is served. Obviously, that's why the petition is being put into place, because there is a fear for their life. But how can that go about if the defendant has guns?
So I've never seen someone actually request that their firearms be taken. I've seen it on the paperwork, because it's on there when you explain things to them that, they need to stay away from here, stay away from here. These are the protected people. This is what they're prohibited from doing, whether it's no negative contact, no contact whatsoever, at all kind of order. it's very dependent. I've never actually ran into the situation where we've actually taken firearms or weapons from someone. However, I have seen it on there as an option for the petitioner to request. Have you seen that or have you had dealings with that where they take
before. Yeah, I've had that before because I've had a criminal case before where she or he needed the order protection. And during that order of protection, we did note that there was firearms in the house, and law enforcement did have to come over there to the place and remove those weapons.
So they are able to request for firearms to be surrendered.
Yeah, they can request firearms, they can request knives, they can request anything that is considered a weapon. They can request that, but usually it's knives and guns that are really asked.
When they're filling out the petition, do they have to explicitly say this is where the weapon is, or just say it's in their home?
Usually it's just kind of like a check mark. If you want to be detailed as possible when you're talking to the law enforcement, when they're going to go ahead and serve it, or you can call law enforcement civil unit and ask them, I know that you guys are serving my order of protection, just to let you know his weapons in the house. Because sometimes the law enforcement will call you and ask, are there dogs on the premises? Are there anything I should know about before I go over to that house? Because, safety for the officer. And usually they'll ask you about the weapons. And sometimes they'll ask you, do you know where that's at? Do you know what kind of gun it is? The client or the person that's making the order of protection will know more information than I do or the law enforcement does, so that is be thorough as possible when you're talking to law enforcement. But sometimes on the paper you don't get that question asked. Where's that? It's just kind of a check mark or a little note where you can write it in.
But it is better to be safe if you do know where they are, where they're stored, where they're hidden, if they're hidden, to be as upfront with it as possible too, because again, whether it be law enforcement or a court ordered process server, whoever it is serving that, they're already going into a volatile environment, and you don't want to have those unknown hazards or threats not known to that person. Because if we're showing up and I say, hey, I'm here to serve this paperwork, and I don't know that this person has guns, for all I know, he could be standing behind his screen door holding a shotgun, holding a pistol, holding a knife, whatever it may be. So if you do know that kind of information, it's better to just be upfront and as open as you can be. It doesn't have to be super detailed, but if you know, like, hey, he keeps his handgun in the car with him, that he doesn't ever bring it in the house, or he has a pocket knife or a hunting knife or whatever on top of the fridge or in this area, wherever it may be, the more information you can provide law enforcement or the process server, the better, just because, again, we're going into an already volatile and unstable environment, given the circumstances and given that there is an order of protection being served or an injunction being served, and you don't know how people are going to react when they get that paperwork. They could get it and say, okay, well, that's not true, I'm going to go contest it. Or you can get someone that just goes completely off the rails and says, why did they do this? They would never do this to me. And then we just make things 10 times worse. And you don't want to add any sort of weapon, firearm, knife, anything to that equation.
I kind of asked this earlier. Let's say they have an order of protection in place or an injunction against harassment, and we're in the social media age. What if they're being messaged on social media, or people are posting to Facebook or Instagram or whatever platform they're using? If the defendant is reaching out to this person over social media or going through a third party, like going through their mom, and their mom is posting on Facebook and saying, hey, you need to contact so-and-so, is that considered a break of the order?
Yeah, so it'll actually include on there too. It'll say, third party contact. It'll have in there like social telecommunications, and even on the actual harassment statute for ARS, it actually lists in there by phone, by message, by
email,
in person, email. It has all those. They kind of blanketed it out and really went into detail because of this day and age and social media and people trying to get around orders and using their friends, using their family to say, hey, reach out to so-and-so for me because I can't. Even doing that, by trying to facilitate that contact, they're still violating that order so long as it's listed in there. And again, it also depends on whether it be a no contact whatsoever, a no negative contact. And another thing with the no negative contact is we have to articulate what we would consider negative contact, because if you're just communicating about, if you have kids involved, you're just communicating about that, or communicating about, whatever it is you guys are dealing with. If none of that ever goes to where we think it's negative, or there's no name calling, there's no constant phone calls, or there's no yelling at each other on the phone or yelling at each other in person, then no negative contact just means that you can still be civil to a point to where you guys can sit down and have a conversation or come to an agreement on something. But if it ever goes sideways and it's, you guys are yelling at each other, you guys are going back and forth over text, then at that point we'll say, I can articulate that is negative contact and you are violating that order.
So this next question I think might be a little complicated or a little hard. I kind of bounced around it earlier. Let's say the defendant or the perpetrator's in law enforcement, in working in the jail or in dispatch, or in some type of law enforcement or first responder. How can a victim go about getting that served? Again, we're a small town, so it kind of adds drama or complicates the situation even more. How would they go about that?
Absolutely. I would still, if it involves law enforcement, if it involves someone from the PD, then I would request, hey, can you have La Paz or can you have the tribal police serve this? And vice versa, if it was, to be served on one of them, they don't want someone within their own agency serving it to them. Mm-hmm. So they would reach out to us, or maybe they would even hire just a civil process server to say, hey, go serve this. Because again, small town, everyone knows everybody. It's hard when you have to be the person to go and serve that, or if you're the one getting it served on, who's serving it to you, how it's being done. So even though, it's someone involved in law enforcement in some sort of capacity, at the end of the day, the judge agreed to grant the petition, grant the order, grant the injunction, whatever it is. So at the end of the day, it still has to get served. It's just now finding a way to not be too involved, but also make sure you're still doing your due diligence and actually getting the job done.
Sure. So
if it was someone from like our agency and it came to us, I would say, hey, you need to have La Paz County handle this, or CRRCS PD handle this, and vice versa. On our level, at least at patrol, we have a really good working relationship with each other to where if something like that were to happen, they can call us and say, hey, I got this order that needs to get served. Can one of you guys come do this? Or can you guys, and we'll do the same thing. We'll reach out to them. Hey, can you come and do this for us? Can you, handle this service because of the situation, because of the circumstances? So either way, don't feel discouraged to not do it because of this person's capacity in law enforcement. If that comes to it, just know that, at the end of the day, it's still a valid order. It still was granted by a judge, and it's still going to have to be served.
I asked if they could file a protection order anywhere.
They can file anywhere in Arizona. AZ Point, you can go ahead and go onto that online site. You can go ahead and file the petition online, and then the petition, once you finish it up and you fill out all the information as detailed as possible, you finish it up, it gives you a little code, like a set of numbers. And you can take that set of numbers and you can go to any courthouse in Arizona and you can file it there. They'll just have to go ahead and take that number from you. They'll look that number up and then they'll go ahead and print it for you. And you just sign that petition stating that it was you who made the petition, that you wrote it. And this is your signature proving all of that. What you wrote is true. And then they'll go ahead and let you see the judge. So you can file it anywhere. Paper ones, though, on the other hand, are specific to each courthouse themselves.
What would an emergency petition or emergency protection order look like?
An order of protection is basically still an emergency order, so it happens then and there. So once you file that petition, usually right away you will see the judge, or you'll see that judge that day. They don't mess with that. They won't order a hearing or anything like that. Usually they'll just go ahead and immediately listen to you or listen to what your petition says and review it immediately. And usually you get an answer by the end of that day of what exactly is going on, because an order of protection is an emergency. It's something that is life-threatening or is gonna hurt you, or it's so it's needed for life-saving purposes.
Not only are we a small town, but we're also a border town of California. And Arizona order protection wouldn't be considered valid in California.
No, it should be considered valid in California because of good faith. Every law enforcement has to, if it looks like it's provided by a court, they have to enforce that order. There should not be any hesitation on that. Once they have that order in hand and it looks and they can try to verify that real quick, they can go ahead and enforce that order. They themselves will have to go back and make sure that the order is correct, and they'll probably call the courthouse or they'll call another agency close to them. So they'll probably call like Parker PD or sheriffs to verify that this order is a valid order. But usually they can enforce it. They can domesticate it immediately, like because it's an emergency order. They'll domesticate it immediately, but sometimes they'll go back. They'll have to verify real quick though.
And I've actually ran into that the other way around where we dealt with a couple from California, and they had an order of protection on file because at the time, and I'm not sure if California is still this way, but at the time, if you got into any sort of domestic incident with your partner, the defendant or suspect in that case automatically got served an order of protection. So that happened. They came to Parker, got into another incident while they were here, running them through the system, their names and date of births and stuff like that. It popped up and said that there is a valid order of protection on file out of California, and it goes back and says, it's out of this county, this date, this time it was served, and it'll actually say, this was domestic violence related. And a lot of times people don't realize that in California that was happening, so they were fixing things with their partner, they were being okay, but they would come to Arizona and they'd deal with us, or we would pull someone over and run their name and we'd say, hey, you have an order of protection on file. It says no contact whatsoever with this person, and putting two and two together, there's two people in the car. Is this so-and-so? Yeah, it is. Did you know that this was in effect? And they go, no, like we had an incident 6 months ago and we're good now. We didn't think anything of it. Had a disagreement, whatever it was. But because California was doing that at the time, they got arrested, released from jail. But in California, they were automatically putting that order of protection into place because of their laws. So a lot of times people didn't even know that, hey, you're, a protected person against your significant other. And it's all because of your guys' previous incident. And then they'll have to actually go back and say, hey, this is what happened. And they'll actually go and request for it to be dropped. Or in some cases where they don't even know it happens and it's actually been in their favor, like we've seen before too. They get into something here in Arizona and, we run their names and it's, you're violating this order of protection. So you're technically committing a crime. And it's hard too because in domestic situations, both parties aren't always upfront and truthful because they don't want to see their significant other get in trouble or go to jail or this, that, or the other. And it kind of ties our hands too because we can only go off of the facts and what's given to us at the time. And if we go and we can see that something obviously happened, but no one wants to talk about it, but we go back and say, hey, you still have an order of protection on file, so you technically are still in violation of it. We're still able to take some sort of action and at least, get them apart for the night or for however long, just to kind of separate them and hope things cool off and they can figure things out. Or maybe even just get someone out of a dangerous situation that, they're not going to come and tell us, hey, he hit me, she hit me, this is what happened. We're still able to go back and take some sort of action and actually help out the victims in that situation.
Oh, I'm so glad I asked that question. You just mentioned a really good point. So let's say somebody does get an order of protection and the defendant gets served. How does that work in their job? So let's say somebody is in like a public job. Is that going to impact their employment if they have an order of protection?
It's just dependent on their job and how involved they are with whatever they're doing. So if they're just someone who works at, an office building and they don't ever see this person, then it's not really going to have a negative effect. And then if they get served, they obviously know that, I can't be around this person. I can't go near this place, or this place. A lot of times, especially in Parker and in small towns, jobs are understanding. They get that things happen. Not everything goes how it's supposed to go. And a lot of places are actually willing to work with you and make sure that, one, you're staying in compliance with the order, and two, that you're not going to be put in a situation to where you're going to have to violate that order for any reason, because no one wants to put you in a situation to where you're going to have to violate something and risk, further consequences.
Mm-hmm. Yeah, I just know that our victims and clients that come in our office are, they want their safety, but they don't want to hurt the other person or make, they want to ensure that they're still successful in whatever they're doing.
Because at times, it's not always about, there's not always a real immediate danger. It could be just, things went bad and, I felt like I needed to get an order of protection. Nothing against the other person, but, that's just where we needed to be,
Awesome. Is there anything else that either of you would like to add?
I think I'm just going to go back and say, again, it might be tedious and it might be, getting old by now, but document. Don't ever feel like you're bothering law enforcement. Don't ever feel like you're being a nuisance, because at the end of the day, again, the more proof you have of what's going on, the better your case is going to be. And then again, going back to, if you do figure things out or things work out in the end with you and the other person, make sure you're really making that decision and thinking about what can happen if you go and request an order be dropped or modified or whatever it may be. But again, if you ever feel like it's harassment, if you feel like it's, your safety involved, by all means call us, call the sheriff's office, call the tribal police, wherever you live at, wherever you're at, call somebody and just document, and always start a paper trail, because you never know if this 1 or 2 or 3 incidents and reports will, help your case in the long run. Because again, it could be good for a little bit. You can, have a bad turn of events. You can document these bad incidents. Things can go good again. And then again, you can fall back into that cycle where it goes bad, and you can still have this proof to go back and say, I filed these things back 6 months ago, a year ago. These are the information reports that I, requested to have documented. Things went good for a little bit, but now, it's going bad again. And I just want to start adding back to that paper trail that I already started in the beginning.
Awesome. So document. Okay. Ashley, is there anything else?
I just think that order protections, if you even think about it or even suspect anything, just get it. You don't want to play with your safety. And even if you don't feel confident enough, or, you don't feel like, this is a one-time event, or, don't play with your safety. If you feel unsafe, call the law enforcement. Call them. Don't take this lightly, especially if there's children involved, if there's pets involved, if there's anybody else, you never know what could happen. Anything can happen at any time. And having to talk to somebody, making that decision is going to be hard. It's never going to be easy. I don't want to say that it's going to be like, okay, you're going to be one and done. I want to let everybody know it's a process a lot of times. And sometimes, just don't give up. Just keep doing what you have to do to protect yourself, and it will work out in the end.
Yeah. And that's a great thing about our office is we do have a 24-hour hotline, and our staff here is here to help. If you or somebody knows wanting an order of protection or injunction against harassment, we are able to help fill that out and help you walk you through the process. And I know that Parker PD has their victim advocate, and she can help as well.
Yes.
Like Ashley said, don't play with your safety, and take control of your safety. Your safety is not something to joke about.
The last part right here is just making sure that order protections and injunctions against harassment, you can apply as many times as you want. That's one of the things that people think, that if I messed up or did the order protection wrong or didn't put a lot of information on and you got denied, you can still go back and redo it again. There's no limits. There's nothing like that. You can try as many times as you can, especially with your safety. Don't be discouraged.
Actually, that gives me a good follow-up question for you. So let's say the 2 years is about to expire of an order of protection. Do they have to wait until the order of protection ends before they can reapply, or do they go and resubmit before it lapses?
Usually when the day is coming up, resubmit it on the same day. Because they don't want to do it beforehand because the order's still in effect, and usually you want to get it reordered as quick as possible. So usually I ask everybody on the same day that you got your last order of protection, file again on that same day, so that way there's no lapse or anything like that. The only time that you would have to go ahead and get a long-term standing order of protection, and that's a whole process too, is if there was a major crime and it shows that you need order protection for a long time. And that goes up to the county prosecutor's office, where they do that whole process to get you a lifetime order protection. So there's that process too. That's a whole criminal process. I hope nobody ever has to do that or gets in that situation where they need that. But there's that option there if the crime is really bad. And we can go ahead and talk to the county prosecutors to get through that lifetime order protection. But usually it's 2 years and you can go ahead and resubmit.
And then again, if anything happened within that 2 years that you had that order protection, or that year for the injunction, if any more incidents occurred, make sure that, again, we're still documenting what happened, and then also adding that to your new petition to show not only your previous incidents that happened, but even after it was granted, that there were continuous incidents, just to be on the safe side. Because even though it's valid and we get involved or it gets documented and something happens, you still want to have some sort of backing to that. Because again, I'm not saying that it won't get approved based on your first, set of circumstances, but if you have more to add to it, that only goes towards your case and helps your case. Because if they violated an order while it was already valid, then that just goes to your favor of why it should be renewed and why they should continue to have that protection order or IAH in place.
Well, I think that is all the questions I have for you guys. Thank you both for doing this and coming on. We appreciate you.
Thank you for having me. I'm glad I could be on here and experience the first podcast like this for myself and not do too bad, hopefully.
Not at all. Well, thank you everybody for listening, and have a great day.
Thank you.
When you're ready to talk, call 888-499-0911. You can also reach out at our website, www.crrcs.com. You can email us at canwetalk@crrcs.com. And you can always follow us on our social medias, Facebook and Instagram.
Cuando estés listo para hablar, nos puedes contactar al número 888-499-0911. También por nuestra página a www.crrcs.com, o los puedes contactar en nuestras páginas sociales en Facebook o Instagram.
Help.
Hope.
Healing.